Good afternoon. My name is Amy Peterson. I am the project associate with the Child Abuse Prosecution Project here at the Association of Prosecuting Attorneys. APA is a private nonprofit located in Washington, D.C., serving prosecutors as well as their law enforcement and community partners. Thank you for joining our Wednesday Child Abuse Prosecution webinar. Today's webinar, Ethics in Child Abuse Prosecutions, will be presented by Edward Chase. This presentation is made possible by a grant received from the Office of Justice Programs through the Office of Juvenile Justice and Delinquency Prevention. APA is very appreciative of their financial assistance and commitment to improving the justice system. Points of view or opinions in this presentation are those of the presenter and do not necessarily represent the views of the United States Department of Justice and the Association of Prosecuting Attorneys. At the conclusion of the webinar, you will be emailed a short electronic to complete regarding this presentation. This survey helps us continue to provide quality training to you at no cost to your jurisdiction and assists in future planning for continuing legal education. Today's presenter, Edward Chase, is a senior attorney with the Association of Prosecuting Attorneys Child Abuse Prosecution Project. He is a former Chief Senior Assistant District Attorney with the Fulton County District Attorney's Office in Atlanta, Georgia. He served as a supervisor of the Crimes Against Women and Children Unit, prosecuting sexual offenses against adults and children, as well as child abuse cases. As a senior attorney with the Child Abuse Prosecution Project, he facilitates training at the regional and national level and provides technical assistance to prosecutors across the country. I will now turn it over to our presenter, Edward Chase.
Well, thank you, Amy, and welcome to everyone who is listening in on the webinar this afternoon. As Amy said, we're going to be talking about ethics in child abuse prosecutions, and I know that it's not necessarily the most exciting of all topics out there, but it's something that's important beyond just to get our ethics credit for our continuing education. It's important to always be reminded about some of the ethical considerations in prosecuting in general, but more specifically when we are prosecuting child abuse cases, because as we all know, child abuse cases carry with them their own set of difficulties. And a lot of times we are having to start with whether a crime has even been committed before we get to who actually may have committed that particular crime. So it, of course, makes our job just that much more difficult when we are thinking about some of the ethical considerations that we need to think about in every case that we prosecute. So this afternoon we'll be talking just in general about prosecutor ethics. We'll review some of those prosecutor ethics and then also talk a little bit about specifically charging decisions and some of the ethical considerations that come in with charging decisions. We'll talk about difficult cases versus cases that we should not be prosecuting, because since a lot of our cases are inherently very difficult, if we just ended the analysis there, we probably wouldn't be prosecuting most of the child abuse cases that come into our office. But a difficult case does not necessarily mean it's a case that we shouldn't prosecute. And so we'll kind of discuss a little bit of how to go through that analysis of difficult versus something we shouldn't be prosecuting. We're going to talk a little bit about external influences, things that might be pushing back on us to make a decision one way or another. Some of those things could be the family or media influences or even our boss. And how do we make sure that we are always making the ethical choice regarding prosecuting these types of cases. And then I'll also talk about always keeping an open mind, and we'll use a bit of a case study for a case that I had when I was still in the Fulton County office to kind of go through the analysis of why it's important to always keep an open mind from the beginning all the way to the end. And that oftentimes includes taking what the defense has to say and at least considering what they are presenting to you. So those are the general topics that we'll be going over today. This cartoon kind of gives a little bit of a background on me. It says, "If it pleases the court, Your Honor, I'd like to quit the defense and join the prosecution." It's a tongue-in-cheek way of saying that I think I have a bit of a different view on ethics simply because I actually started off as a public defender, and I spent the first several years of my career in the courtroom handling cases from the defense side. It was actually handling the child abuse type cases that made me want to switch sides. But I think I've always kind of brought with me that perspective of having been on the other end, having dealt with sometimes prosecutors who I don't necessarily know if they were living up to the ethical standards that we should all be living up to. Maybe hiding things outright or shading things in a way that may not necessarily have been true, playing games with discovery. Those are all things that we need to be reminded of when we're prosecuting and why it's important. So I think I have kind of a different view in that I see it definitely from both sides, having been on the receiving end at one point. Just a little bit about the case law as far as what is required of us. And I know that Berger versus the United States is a very old U.S. Supreme Court case from 1935. But it essentially outlines what I think is kind of what we all should be living up to today. And the part that's in bold states, while he, and of course, since it's an old case, it was sexist and did not, and obviously assumed that all prosecutors were men. But while he may strike hard blows, he is not at liberty to strike foul ones. It is as much his duty to refrain from improper methods calculated to produce a wrongful conviction as it is to use every legitimate means to bring about a just one. And that should essentially always be our guiding light as far as what is within bounds and what is out of bounds when we're prosecuting these particular cases. So I point that out. It's an older case, but it's still very much relevant to our work today. So ethics in charging decisions. When I teach this class live, I have a more interactive section here, but I guess I'll answer my own questions as I put them up in this particular section. So are there any issues in the following common charging decision areas? So the first one being charging in the alternative. For example, we have a case and we could either charge rape, being that it was forcible and against the victim's will, or statutory rape. We're not necessarily sure if we can prove the force against her will, but we can definitely prove that she was underage. Is there anything unethical in doing that? And the answer is pretty much resoundingly, no, there's nothing unethical with doing that. It's a very common charging decision that we make. How about including every lesser charge that's out there? And there's nothing unethical about that. There's nothing unethical about charging every charge that we believe that we have a factual basis to prove. Of course, this may be more of a strategic decision versus an ethical one. But do we want to put everything on the particular indictment? Are we in a jurisdiction that will automatically have lesser included that the jury will be given? Or are you in a jurisdiction like here in Georgia where the jury isn't necessarily going to get lesser included charges, so you may want to put lesser charges on there, or you may specifically not want to put lesser charges on a particular indictment. But there's nothing unethical about doing that. Charging every incident in a long-standing abuse situation. And by this I mean identifying every date versus one count of, say, child molestation with a giant date range. And there's nothing unethical with doing that. Charging knowingly weak charges to make the indictment seem more severe. I think this is where we start to get into some ethical problems. If you have a case and you have some weak charges and you have some stronger charges, is it ethical to put the ones in there that we know we are most likely going to lose? We don't have the evidence to prove. We're not really sure about the veracity of the charges, just because we want, when the judge, say, reads the indictment to the jury, it to sound extremely bad, but in the end we don't care what ends up happening. I think that's when we start getting into ethical problems. We should only be prosecuting cases and charging cases where we know that we have the probable cause and the evidence to be able to support those particular charges. And then what about charging weak 404B or 414 evidence in the indictment? If you're in a jurisdiction that allows for other acts evidence to come in, in some jurisdictions you can actually include those in the indictment if it's, let's say it's a course of conduct type scenario. If we know some of those to be weak and we may not necessarily get them in under 404B or 414 or whatever your state's other act evidence statute may be, is it ethical to just throw them in the indictment knowing again that we may lose them? And again, I'd probably say that we're definitely not on the right side of the line in those type situations. We need to remember always that we should always be presenting charges and presenting cases that we have the evidence to support. We always want to maintain our credibility in the courtroom, but not only in the courtroom. We'll also talk about a little bit later on how a lot of these decisions can have impacts beyond the courtroom. It can affect not just us personally or the case that we're working on, but can affect the entire community. So how do we determine which cases are borderline cases and which cases we should charge and which cases we shouldn't? Obviously, that's a case-by-case determination. I can't sit here and give you a checklist of exactly what you need to charge and exactly what you should be looking for to dismiss a charge. My general rule is that I must be convinced before I ask the jury to convict someone, and that's kind of the rule that I use to determine whether or not I believe that we have the sufficient evidence to go forward to present to the jury. But that's what makes these things tough, and that's what makes these evidence presentations tough, is because a lot of what we talk about is the gray area. But the important thing is to continue to remember, to go back and to remember what our guiding principles should be. It's important to remember the other side. It's important to remember that we represent the citizens of the state. We represent the victims, we represent the population in general, and in a way, we also have to represent the rights of the defendant. We are not representing the defendant in the courtroom, but we always have to be cognizant of the repercussions that could come upon a defendant for the actions that we take. So some of the things to consider: is it ethical, based upon the facts that you have, to put that particular defendant in jeopardy? You know, we can decide, we're just going to go to trial and let the jury decide. But, you know, there could be a situation where if we just do that and we don't necessarily think he's guilty, or we don't think we have the evidence, we could mess around and the defendant could be convicted. So is it ethical to just throw it up to the jury and let them decide? And that's why a lot of these tough decisions need to be made by us. We have to, I think, remember the consequences of formal charges. In certain states, a defendant may not be able to restrict their record after an indictment has been returned. So indicting someone, and then even if we have to drop the charges later on, still could have repercussions for that particular defendant for the rest of their life. I would venture to say that if an employer went to run someone's criminal history and they saw a rape charge or a child molestation charge, it doesn't matter if it says null pros or exonerated or whoops, we made a mistake next to it, it's still going to definitely have repercussions for that particular defendant. So of course those are things that we need to be, we always need to think about as well. Societal backlash. Jury could find someone not guilty, but again, it kind of goes back to what we just talked about, the consequences of formal charges. The defendant will probably still face some sort of societal backlash with these types of charges, and then of course family and personal repercussions, that the effects that it could have on the family. Obviously, if we believe in a case, if we believe that the defendant has committed these particular offenses, then we should go forward and we should zealously prosecute. But especially on the cases where things are not quite as clear, we need to be cognizant and be thinking of all of the repercussions, and not just looking at the 4 pages of the page in front of us, or excuse me, the 4 sides of the page in front of us. Another consideration regarding charging is particularly, should we make a charge? One of the greatest responsibilities that we have as a prosecutor is prosecutorial discretion. And so one of the things we have to consider is, even if we have the evidence to support a particular charge, should we do that in every situation? I'll use an example from Georgia, simply because I practiced the majority of my career here in Georgia, so it's just easier for me to grab an example from here. In Georgia, there are, as you see on the screen, there's statutory rape, and then there's aggravated child molestation. And I'll just briefly go through what is involved for each. Statutory rape involves the vaginal sex of a female under 16, and the male is either between 17 to 21. That has one sentencing range. Or if the male is over 21, it has a more severe sentencing range of 10 to 30 years. with no probation on the first 10 years. So obviously that is involved there is a male perpetrator and a female victim, vaginal sex, where she's under 16 and he's either between 17 and 21 or over 21. For aggravated child molestation, that the statutory requirements are oral or anal sodomy. One party is under the age of 16 and the other party is over 17. So we're talking about the same age range here. I put up here there's no Romeo and Juliet exception because it doesn't matter if, in this particular case, if the person is between 17 or 21 or over 21, the sentencing range is exactly the same. In this particular case, again, consent is immaterial, just like statutory rape. The consent is immaterial, but the sentencing range is 25 years without the possibility of parole, plus the remainder of your life on probation. So essentially what we're talking about here is the ages being the same. However, one involves vaginal sex, the other involves oral anal sodomy, and the sentencing range is drastically different. So the first question is, if you have a case where one person is, that comes into the office and the defendant is, let's say, 22 years old, the victim is 15 years old, and they engage in oral sex. Should we charge the defendant with an offense that carries a minimum mandatory penalty of 25 years plus the remainder of his life on probation, whereas if they had engaged in vaginal sex, the sentencing range would have been drastically different? And one point of view on that is, well, that's what the law is, and that's what the legislature has decided, and that's what we should do. We should prosecute the laws that are violated, and that's a legislative issue that can be taken up at the Capitol. Another perspective is that while that may be true, should we explore other options? So, for example, in this particular case, in Georgia, the defendant could also be charged with regular child molestation. That only involves an immoral and indecent act with a child under the age of 16. The sentencing range is vastly more in line with the statutory rape. It's 5 to 20, and with still a pretty severe penalty, but it's more in line with the statutory rape. So should we use our prosecutorial discretion to charge something that is more in line with the statutory rape charges? And that's something that's very independent and very unique to each prosecutor's office to kind of make that decision as to what is best. In Atlanta, we had decided that we would charge under the child molestation as opposed to the aggravated, simply to make it more in line with what was very similar conduct. That would have been vaginal sex. So something to consider. Should we look at other charges if perhaps societal norms have changed and maybe the legislature maybe hasn't made a correction or hasn't decided to go back and take a look at the sentencing ranges, because we know that they don't necessarily go back and look every single year at every single statute that's on the book. Some other things to consider beyond is this fair? Are you going to get any sort of constitutional arguments? As far as charging one act differently than charging a very similar act, could you be dealing with constitutional challenges on those particular charges? So those are just some things that we should think about when we're thinking about how to charge a particular case. Physical abuse cases, I'll just point out some of the things I think we need to be cognizant of when we're talking about physical abuse cases and charging. First, I think we need to be thinking, of course, about, is this abuse or is this an accident? Most of the time, that's going to kind of be the defense out there. So we need to be considering it from the get-go. Is this abuse or is this accident? One of the things I would say that you need to look at first is the quality of your medical opinion. Who is making the determination from a medical standpoint? Because most of the time it's not going to be us. Who's making that determination from a medical standpoint that's saying that this is child abuse? Do you have a child abuse pediatrician who's making this particular determination? And therefore, they have a whole lot of experience dealing specifically with child abuse situations. Or is it a medical opinion that's coming from an ER physician, an orthopedic doctor, or a regular pediatrician? That's not to say that those doctors are any less of a doctor. That's not to say that this very well could be child abuse. But is the quality of the medical opinion going to be different? And that's something that we need to determine. How much experience does the medical professional have in making a specific opinion on child abuse? Because beyond just the charging decision is something that we're going to have to deal with when we get to trial. So you definitely maybe even want to get a second opinion regarding whether or not this is abuse, how likely it is that this could be accident. It may be good to get a second opinion on the front end. I would also point out that throughout the case, it's going to be important to continue to communicate with medical professionals. Medical opinions can change over time, just like our opinions on a case can change over time because we may get different information. There was a case that I handled in Atlanta where the defendant, initially it was believed that the defendant inflicted intentional harm upon her child. That's what the initial diagnosis from the child abuse pediatrician was. However, there was some additional testing that was done several months later because the child actually remained in the hospital. And based upon that additional testing that was done several months later, the doctor had actually changed her opinion to she could no longer be sure if it was actually abuse or not. She didn't say it was accident, but she said that she could no longer be sure. But that information was never relayed back to the DA's office. And when I sat down to meet with her, when I inherited the case, and this was a couple years later, she basically advised me that her opinion had changed based upon additional information, and that had not been communicated to the police department and hadn't been communicated to the DA's office. On the flip side, no one had gone back and asked her if anything had changed. Ultimately, the charges had to be dropped, and the child was removed from her mother's custody for over a year. So there, again, real consequences of not keeping in that constant communication to determine whether or not any sort of medical opinions had changed. You should always consider the possibility of an accident, even if that it can be quickly dispelled. No one's saying that we have to sit here and contemplate for days, weeks, months, and years whether or not this is accident. I mean, a lot of these scenarios can be quickly dispelled, but I think it's incumbent upon us as prosecutors to consider all the sides. With nonverbal victims, how do we identify the correct perpetrator? This is a common scenario that we have when we have nonverbal victims being abused. One of the things we often encounter is that multiple adults could be in the home or have access to the child. How do we identify who the correct person is? Even if the doctor can tell us that this is definitely abuse, there's absolutely no way that a child, falls from a bed onto a carpeted floor and has 14 skull fractures from a single fall like that onto a carpet. It just doesn't happen, right? But how do we identify the correct person? Oftentimes we find family members who point fingers at someone else in the home. It's always someone else did it. And then, of course, could it have been someone outside of the home that inflicted the harm? Could it have been a child care worker, a teacher? So identifying that person can be very hard. I will say this, that it is not sufficient to make a best guess. And I say that from supervisory experience, that someone actually said that maybe we just make a good guess and leave it up to the jury. From an ethical standpoint, that's a big no-no. It's not sufficient for us to just throw it up and see where everything lands and leave it up to the jury. Again, it's not appropriate to charge everyone and just see where the chips may land. But also consider that even if we're not able to present enough evidence to be able to identify a certain person as inflicting this particular abuse, consider other charges. Could there have been charges of neglect? Can we charge the mom with neglect for knowingly leaving her child in the care of someone who she knew to be abusive? So considering other charges beyond what may seem like the most obvious one could also be important and could fall well within the ethical boundaries. Disclosure of information. So that's something that we as prosecutors deal with all the time. What information do we need to disclose? Well, the ABA's rule on this falls under 3.8. It's the special responsibilities of a prosecutor. A prosecutor shall refrain from prosecuting a charge that the prosecutor knows is not supported by probable cause. And I think we've talked about that a little bit already. A prosecutor shall make reasonable efforts to assure that the accused has been advised of the right to counsel and has been given reasonable opportunity to obtain counsel. So the ABA actually puts that on us, that we have to make sure that the defendant has the right to counsel and has been given the right to obtain that counsel. Not to seek to obtain from an unrepresented accused a waiver of important pretrial rights. So we shouldn't be walking up to them and saying, hey, do you waive your right to file that motion to suppress or whatever it is. And then it's also incumbent upon us to make timely disclosure to the defense of all evidence or information known to the prosecutor that tends to negate the guilt of the accused or mitigates the offense. And that's a little bit different than Brady. The ABA rule is definitely a little bit broader than what we commonly think about when we think about with Brady. So Rule 3.8D, specifically the disclosure, it requires the disclosure of evidence or information favorable to the defense without regard to the anticipated impact of the evidence or information on a trial's outcome. And that's where it differs from Brady, because Brady basically says it has to have made a difference, right? The rule thereby requires the prosecutor to steer clear of the constitutional line, erring on the side of caution. And when I speak to prosecutors, I always tell them just err on the side of caution. When it comes to disclosure of information that you receive, err on the side of caution of disclosing things, unless they are protected by some other statute. In Georgia, we were not allowed to turn over Child Protective Service records directly to the defense. We would have to turn them over to the judge, and the judge would have to do an in-camera inspection to determine what, if any, records were relevant for the defense in a particular case. So there may be statutes that prevent you from turning things over, and of course you should abide by the law. But as far as anything else, I always say err on the side of caution because you just can't get in trouble that particular way. It may be better to turn something over and fight about its admissibility in court. Something may come across your desk that you know is going to be inadmissible, or you think is going to be inadmissible, and you can fight about the admissibility later on. But it's easier and it's better and it's cleaner to have more of a bright line rule of I'm just going to make sure that I disclose or turn over everything that could potentially be beneficial to the guilt or innocence, or even to the sentencing as far as the ABA rules are concerned. Obviously, the ethical rules prevent attorneys from lying to opposing counsel. But what about when we omitting information? Is that also a lie? I mean, omission can be a lie, and maybe a far more gray area. If we are holding back and we're not telling things that are explicitly exculpatory, I think that's clearly something that we should not be doing. But even holding back on other information, you got to kind of think in your head, is this fair? Is this living up to my ethical obligation as a prosecutor and as an officer of the court? Obviously, you can't fabricate evidence or information, and I know no one is out there doing that. Let me ask you this particular scenario just to kind of think about. And this is kind of a what would you do situation. Let's say that a witness in a particular case is the essential witness for the prosecution. You cannot prove the case without this particular witness. Would you notify the defense if the witness recanted their statement? And of course, I always put the easiest one first because yes, if the witness recanted, then we should definitely be telling the defense about the recantation. Again, recantation can be explained. And there are several cases that I've brought to trial with recantation issues, and you explain it to the jury, and the jury makes the determination as to whether or not that recantation is valid or because of some other sort of reason. But of course, you have to disclose it. What about if the witness died? And when I teach the live classes, most people say, absolutely. I mean, you would have to tell them that. And that's kind of there may be a bright line rule in your particular state, and if there is, then obviously you need to follow it. It's not as cut and dry in all states. In fact, Arizona, and I think it's on the next slide, Arizona specifically has a ruling from their ethics committee that states that you do not have to tell the defense if a witness has died. So there's that. It's kind of that gray area. And then if a witness was missing leading up to trial, do you have to tell the defense that? No. I mean, if we did that with the cases that we prosecute, we'd be on the phone with them all day long, right? What about non-evidentiary information? The discovery rules may not require information may not require the information to be disclosed if it's not exculpatory, not relevant, not to the guilt or innocence or to the punishment. And again, I talk about that Arizona's case saying that we don't have to turn over the fact that the witness died, but should we disclose the information? And that's the ethical consideration that you should ask yourself. Of course, there's competing interests here. You know, we don't want the defendant to get away with a crime because of unforeseen circumstances. You know, the outcome, if by turning over certain information, the outcome could be potentially inconsistent with the seriousness of the crime. And is that justice? Is it justice if the defendant happens to get away with a crime simply because of something that was outside of our control or some additional information that came about that could be damaging to our case? On the flip side, though, we have to remember the defendant is making a life choice. Now, the defendant, from our perspective, has already made some bad life choices that got him into this situation, and so we're not overly sympathetic to necessarily to the defendant and their plight because, from our perspective, they put themselves there. But the defendant is making a life choice based upon all the information that is known to him or her at the time. And if we have a higher ethical obligation, do we have an obligation to provide the information we may not be required to disclose? Again, these are these ethical considerations that we need to consider while as the cases progress, because they're going to come up. You know, life isn't nice and clean all the time, and sometimes these issues come up and it really affects our cases. Keep this in mind when you are making that determination, that withholding Brady and pleas, some federal circuits have actually held that withholding Brady material will violate the voluntary and intelligent requirement of the guilty plea. So there's several cases, as you can see on the screen, that the defendant ended up taking a guilty plea, but it turns out that they didn't know certain Brady information, so information that would be classified under Brady when they took that particular plea. And so the courts have held that not knowing that information when they took the plea violated the voluntary and intelligent requirement. So just dumping a case when you have bad evidence come your way and hoping no one finds out could actually result in the case coming back years later when the case is even worse because even more time's gone by, simply because you did not turn over that information. So don't always think that just dumping the case is oh, that's my way out of this. We're still required to tell the defendant of exculpatory Brady type information prior to them taking a plea. And if they want to take a plea after they know that information, then that's totally within their prerogative. Winning. Obviously, not many prosecutors like to lose. It's not something that is really ingrained in our DNA. We like to prevail on the cases that we're bringing to court, and especially these child abuse cases, because we get very passionate about them. Again, I think we're also kind of trained to win in law school, and so it's something that we've been taught to do. And I say this in the context of sometimes we may have very, very good intentions, but this kind of winning attitude can sometimes get the best of us. I will say I had a good friend here who put a case up, and I will say that I think he was a very, very ethical, one of the most ethical prosecutors I know. But he got caught up, and he knew going in that the victim had recanted a certain portion, not all of it, but a certain portion related to one particular charge. And he put it up to the jury, and the jury found the defendant not guilty, when the victim recanted on that particular issue, but found him guilty of the remaining charges. And the jurors asked, you know, why did you put this particular charge up? And he said something to the effect of, I thought I would just see what the jury would do with it. Said this in front of defense counsel, and I would say this to the defense counsel's credit, I don't think they thought that he really thought through what happened, because the recantation came in like immediately before the trial. It wasn't something that happened months ago. It was kind of within the context of the trial. The defense did not bring an ethical violation, and the defendant was granted a new trial. But the defense didn't bring it because I think the defense knew that the prosecutor just kind of got caught up and, in retrospect, would never have made that mistake again. but another lawyer in the community heard about it and made a recommendation to the State Bar Association. And that attorney had to deal with the State Bar for many years on that particular issue. So I say that as a warning to all of us out there that we always have to be cognizant of this, even if we are in the midst of trial, we're kind of wound up. You got to take a step back. You got to remember what our ethical obligations are, because even in the heat of trial, you don't want to get in a situation where you're making these unethical decisions that'll A, affect the case, or B, affect your license, because that's not where you want to be. How misconduct can affect the profession as a whole. Obviously, our system of justice, and this is per the Brady decision, our system of justice suffers when any accused is treated unfairly. So it affects how the jurors and how public view the criminal justice system. And I think that we are all seeing a shift in how the general public maybe views the criminal justice system a bit differently than they used to. Every time someone is perceived to have been treated unfairly, whether it's true or not, whether or not someone is perceived to have been treated unfairly, it affects how the jurors and how the public view the criminal justice system. It affects other victims of crime. They may not be able to get the justice that they deserve in their particular case because of some of that spillover effect. And it also affects other prosecutors' ability to obtain convictions by the rules. If we as prosecutors are kind of getting a bad name in the community because we take shortcuts, we don't do things by the book, the ones who are doing things by the book may also suffer from that. So it goes beyond just you and your particular case. These are just some pretty recent headlines regarding child abuse cases and how the prosecution has ended up in the headlines over prosecutorial misconduct. And again, this kind of will have a cumulative effect, a snowball effect on the profession as a whole. So we'll talk a little bit now about difficult cases versus cases that we just shouldn't be prosecuting. There's nothing to suggest, again, that you shouldn't be prosecuting a difficult case. Difficult cases can include things that we all encounter on a regular basis: delayed disclosure, memory issues. Victim, maybe is not remembering things, several years later that they recalled at the time. Family issues: is there pressure being put on the victim from other family members? Juror doubts, recanting victims, no physical evidence. I mean, usually if I ask in a live class how many people always have physical evidence in their case, in all their cases, no one raises their hand, right? Because it just doesn't happen in these particular cases. So obviously those are going to be difficult, simply because of what we're dealing with jurors, because they expect there to be evidence. Victim credibility. Do we have victim credibility issues? Not all of our victims are as innocent. Maybe the perception of them, their innocence, maybe not as great as we would hope. So those are things that we have to deal with in front of the jury as well. And then uncooperative families. So those make them difficult cases. I would urge you to look at, determine whether or not there are any red flags, and always taking a look at the big pictures. So when we're looking at red flags, are there any family issues that may be present? Are there, I hate to start off with the most cliche one, but is there a custody battle? If there is a custody battle, that's something that we have to at least consider, right? Beyond just our ethical obligations, we have to consider it because as soon as the jury finds out that there's a custody battle, the jury is going to be considering it. No matter how much the defense brings it up, the jury is then going to be considering, oh, well, there's a custody battle there, so that gives the victim a motivation to lie. So we should be thinking about all those issues on the front end, not only from an ethical consideration, but also from just a case, preparing our case perspective. Are there mental health issues with the victim? Does the victim suffer from a disorder that might have them hallucinating? On the flip side of that, though, if a victim does have mental health issues, is that the perfect victim? Because as we know, the majority of the offenders are known to the victim. So if someone does have mental health issues, the offender probably knows that they have mental health issues and pick them because who's going to believe them anyway? So it's, of course, taking a look at that big picture and considering any red flags, but considering red flags in the context of the entire case. Is there any conflicting physical evidence that may point one way or another? And then, of course, is there any exculpatory evidence? And we'll talk a little bit about the case study as far as exculpatory evidence when we look at the big picture. On the screen, I have a slide that I normally put up for in every closing that I ever do. And I explained it to the jurors in the context of, let's say that my job here today was to prove to you that the photograph that you see on the screen is a photograph of a $1 bill. And the evidence that I've been able to bring to you to prove that are the puzzle pieces that you see on the screen. Now, as you will notice, there are some puzzle pieces that are missing. And so what's the defense going to say? Well, the defense is going to say that if there's any puzzle pieces missing, then the state has not proven their case beyond a reasonable doubt. But what does the law say? The law says that if you take a step back and you look at that photograph and there's no other reasonable explanation as to what that is a photograph of, then the state has met its burden of proof. I say that to the jurors to explain reasonable doubt, but I think it's also a good way to think about these cases and the red flags to begin with. Independently, we may be able to justify perhaps one red flag. But if we take a step back, are there too many red flags that are present? Similarly, if you take a step back and you may have a couple red flags out there, but the evidence is so strong one way or the other, when you're taking a look at the case as a whole, and not just looking at one little thing in a vacuum, you get a much better picture and a much clearer picture as to how you should proceed with the case. One of the I asked this when I teach this course is, would you prosecute when you have would you prosecute this particular case? And this is a case that I actually had where it was a delayed disclosure. The victim was 7 to 9 years old when she was abused, but she didn't outcry until about 6 years later when she was 15. The defendant was her stepfather, and the mom divorced him several years prior, and there had been minimal recent contact. She outcried to a paternal grandmother, but she was adamant that she did not want her parents to know. There was absolutely no physical evidence because 6 years had passed. And in the forensic interview, there was pretty limited detail as far as what had occurred. A lot of that was most likely due to the amount of time that had lapsed, but also this was something that had occurred regularly over a 2-year period. Mom and the defendant did share custody of a biological child, but that was not the victim. But there were no real custody issues. So obviously we have a very limited case, a tough case, with no physical evidence. But we also didn't have, when we took a step back, we did not have a reason why she would lie. Like, why would this young lady who had, there was no problems there, there was no real contact with the defendant, he was out of their life, why would she make it up? And ultimately the jury struggled with that for about 2 days, but that's the determination that they made as well. That even though they had limited evidence, even though there wasn't much for them to go on other than the victim's word, at the end of the day, when they looked at it at the big picture, there was just no reason for her to make it up, and so they convicted him. So that's why I use that as an example of don't just focus on the fact that we have very limited evidence, or we have we don't have anything to corroborate, or the forensic interview is very thin because she wasn't able to give a lot of detail. Take a step back. Why would she have lied? Why would she have made it up? External influences we'll talk about quickly. External influences can include the parents and family of the victim. There obviously can be very pretty animated and pretty involved in the particular case. Your elected official or your supervisor may be an external influence. The media, investigating agencies, or other MDT members, because we have to remember they had the case before us, and so they have an interest in seeing the case come to a conclusion as well. And then sometimes even neighbors. I had a case where the neighbors all called me more often than the family did. So sometimes you get the neighbors banging on your door as well. So how do you handle those influences? Your boss, you That's a tough one. Your boss or your supervisor. You do got to remember though, if you feel that strongly about something, that your license is the one that's on the line. They're not going to come pay your bills. They're not going to be the one to support you if something happens and you lose your license. The best case scenario, you just ask that the case be reassigned, and if you have true issues with it, then perhaps they're willing to go ahead and do that. The media, it can be unpopular it can be hard to make an unpopular decision under the media spotlight. Without harping on it too much, I'll just say if you are making the legally correct decision, that should always be what our guiding light is. It may not be the popular decision, but making the legally correct decision really needs to be the standard that we are abiding by. Remember when you're dealing with family that the family may be approaching this from a very emotional standpoint, whereas we are approaching it from more of a clinical standpoint. They're not concerned with due process. They're not concerned with our ethical obligations. And it's your job to maintain that emotional distance and to the best that you can explain to them. And it may be difficult at times. It may be very difficult at times. But what I've sometimes said to them, to certain family members when appropriate, is to kind of explain it like a doctor. That you wouldn't want your doctor, when they are making decisions on your health, you wouldn't want them making an emotional decision either. And so that the same should be said of us as well. That we need to be making these decisions free of the emotion, and the family, of course, is able to feel whatever emotions they may have about it. Another thing to consider is whether or not that passion is a red flag. Always keeping an open mind is a family member who is overly interested in prosecuting. Is that, when we're taking a step back and looking at the big picture, is that another red flag that we should be considering? We'll finish up by talking about keeping an open mind and why it's important to do that. Another cartoon for you. Could my client be innocent? Probably not, but the point is it's interesting to think about. It's kind of just more of a funny as to why it's important to think about what the other side has to say. Again, we don't have to sit there and consider it for months and years. But I think that we should at least consider it, even if we consider it and we dismiss it pretty quickly. We should be considering the evidence or the information that's brought to us by the defense. It can be hard to do that sometimes because prosecutors learn to become cynical to a certain extent because they don't want to be taken for a fool. We don't want to be the ones who are taken advantage of because we are naive. That definitely would not be something that we would want. But also remember that not everything that the defense presents is false or misleading. We have to think that way is to shirk our own ethical obligations, and we need to be evaluating all of the evidence that's presented to us. I'll use the example of state versus stepdad. So in this particular case, there was a 15-year-old victim, and it was alleged that her stepfather raped her when she was homesick one day from school. She couldn't give a specific date, and so the indictment alleged a date range. And the way that the cases worked here in the Atlanta office were that there was an indictment team and then there was a trial team. And so I don't know all the information that was that the indictment team dealt with because I was the trial attorney. But she couldn't give a specific date, so the indictment alleged a date range, which of course is not unusual in these particular cases. She outcried in September, and she outcried to a friend because she thought that she was pregnant. Her mom and stepdad had divorced around the time of the outcry, and so there were child custody issues over the younger biological child. The victim gave a relatively detailed account, though, of the abuse in the forensic interview. So it wasn't a situation where she walked in and gave no details. She gave actually a pretty detailed account of what happened. She also spoke with law enforcement, and there were some inconsistencies that were noted in the pre-indictment phase. But when you kind of took it in each individually, there were ones that there could be an explanation for, such as the placement of the defendant and the victim during the actual abuse. She originally told the outcry witness that the victim went to the room and he told her to come in. To the law enforcement and to the forensic interviewer, she said that she was asleep and the defendant came into her room. Maybe she didn't want to tell the friend everything. Maybe she told the friend just a little bit of the information, but to the law enforcement, the forensic interviewer, she was consistent with what she said. Removal of the clothing. She initially told the law enforcement that the defendant removed her clothes. She told the forensic interviewer that he told her to remove the clothes. Individually, was this an unintentional inconsistency? Was it trauma related? Because we know that trauma affects our memory and affects our ability to recall. So was it an inconsistency that was a lie, or was it just an inconsistency related to her memory at the time? The initiation of the sexual contacts. To the outcry witness, she didn't mention any threats. To the law enforcement, she did. Was that just she didn't want to mention the threats to that particular person? And then contact after the assault. She told the forensic interviewer there was no contact, but the evidence that we had and also that the defense provided showed that they did have some contact, some very limited contact. Perhaps what she thought the forensic interviewer meant was sexual miscontact. So these inconsistencies, and I put it in quotes because they may or may not have actually been inconsistencies as far as a lie, but some inconsistencies can be common in a lot of the cases that we deal with. We have to remember that the human brain doesn't work like a video recorder, and the child's memories are especially prone to, quote, inconsistencies due to development. They knew that it was going to be a difficult case, but the decision was made to indict because they looked at those and said, well, there could be an explanation as to why that could be. Post-indictment, the defense obviously became much more involved and began to communicate a lot more information directly to us. Now, first they gave us a polygraph examination that said that he denied sexual contact and then said he was telling the truth. But of course, how reliable are those, and what weight, if any, should be given? And at the time, not a whole lot of weight was given to the polygraph examination. We spoke to the forensic interviewer, and interestingly note, the forensic interviewer didn't note any signs of coaching, and she also stated that the victim was quite detailed. But she did find it odd in this particular situation that there was no grooming, that there was absolutely no grooming that led up to this particular situation, that the father just stepfather walked in, committed this act, and then, according to the victim, left the country later that day. And the forensic interviewer found that to be odd, that he did not stay around to make sure that the victim didn't tell anyone, that he left the country for about 2 weeks and then came back to the particular home. The date of the incident, we were able to determine that the date could only have been one day that she was out of school. And on that one day, it could have only occurred during a 30-minute window when mom was en route home to actually take the defendant to the airport. And when they went to the airport, the entire family went. There was a photograph that actually was taken of the family at the airport, and in that photograph, the victim appeared to be exceptionally happy. Now, of course, again, that's something that independently you might be able to explain, that even though she was abused, maybe an hour or two before, that she was able to kind of suck it up and be okay. But the problem is that with the time that her switching the time of when it happened, saying that initially that it happened only in September, but we were able to track it back to this one day in March. That would have been the only day that it could have occurred. Things started to add up as far as a lot more red flags that were popping up during the course of the post-indictment investigation. We also, the defense let us know that the victim had a history of mental illness, and that's something that we had a general knowledge of, but not specific. And during an evaluation of her mental health history, she did in fact have a long history of mental health that included issues of hallucinations and habitual lying. And these were things that were noted by psychiatrists long before the incident had occurred. So again, another red flag that pops up. And these are things that are coming from the defense. So the ethical question is this a lying victim, or is this the perfect victim? Because who's going to believe her? Who's going to believe this young woman, especially the stepfather who has all this information about her? Are these inconsistencies lies, or are they a result of the trauma? The photograph, which of course I didn't put in this particular presentation, and I don't use the actual photograph, but more of a representation of it. Is that good evidence, or is that something that's easily explainable? And another red flag is the mother was adamant that we present the case to the jury. And again, this is in the context of the mother is going through a very, very heated custody battle with the defendant. Is that a passionate mother because she's upset that we were at that point informing her that we couldn't prosecute the case, or is this a red flag that she has a desire for us to go forward for other reasons? And the difficult aspect of it is, to this day, I can't say for sure one way or another what happened. I cannot say for sure one way or another if he didn't do it, and I can't say for sure that he did do it. And that's kind of when we took a step back and we really looked at the case as a whole, that's kind of the answer that we came up with, that we could not definitively say one way or another whether or not. Now, some say one philosophy is that if the victim says that it happened, we present the case to the jury and let them decide. But is that ethical? With all of those red flags, with all of those issues, was it ethical for us to go forward? And the thing about these ethical questions is that reasonable people can disagree. And another prosecutor may have, or another prosecuting office may have come to a different determination. But this is the analysis that you all should be going through when you're making these decisions. And then whatever decision you come up with, is likely going to be a valid decision. So again, I put up the picture of the dollar bill just as a visual reminder of kind of what we should be doing when we're evaluating the cases. If you have questions, beyond contacting us at the Child Abuse Prosecution Project, the American Bar Association does have ethics resources online, and then most states also have a ethics resource through their state bar that you can ask ethical questions. And then the Association of Prosecuting Attorneys Child Abuse Prosecution Project, we do offer a whole range of assistance to prosecutors and their multidisciplinary teams, including free trainings, obviously the webinars that you were on, as well as monographs, newsletters, and other items to be able to assist you to help make your lives a little bit easier. I'm not sure if there are any questions. I don't believe that we have any questions unless I'm incorrect about that, Amy.
No, I haven't received any questions. So if anyone has any questions, they can definitely email us through our website or at webinars@apainc.org, and we will get back to you. Thank you, Edward, for a great presentation this afternoon. All APA webinar materials and recordings are available on our website. Thank you for attending and have a great day.